Good afternoon, everybody. This is First Appearance Courtroom. My name is Steven Zakor. I'm the presiding judge. The purpose of today's hearing is to inform you of what you've been charged with and determine if there's probable cause to hold you for those charges, determine what the appropriate bond is, and any other release conditions that may be appropriate. What's your name, ma'am? Hit the button on the mic there.
Judge, this is Ms. Gonzalez. Mr. Kirch is in the courtroom. She's his attorney.
Okay. All right, Ms. Gonzalez, I'll be with you 1 second. Just for everybody else, everything's being recorded both by video and audio. Members of the state attorney's office are present. So if you say anything about the facts of the case that they decide is useful, they can use it against you. So don't talk about the facts of your case. Try to limit it to your time to the community. Answer the questions asked if that occurs. We'll start with Francesca Hillary Gonzalez. Attorney here on your behalf, ma'am. I think we reset this for this morning, right?
Yes, and Mr. Miller contacted our office, Neil Kirch, with the law offices of Anajar and Levine. I would invoke her right to remain silent and have an attorney present during all question. I have no objection to the probable cause. I'm only here to discuss a bond amount.
Okay. All right, Mr. Leader, any criminal history?
No, Judge.
No history. Contact with the victim?
I think he's
I believe he's present in the courtroom.
Oh, all right. Come on up, sir. Your name? My name's Brian Sentinel. This one this morning. Let me refresh my memory. Mr. Quintanilla?
Yes.
What is it you'd like me to know?
Sorry?
What is it you'd like me to know?
I'm just here to see what happens.
Okay. What do you want to have happen?
What's best for her? I don't want anything to happen to her, honestly.
Okay. What do you think's best for her?
Get through this situation and whatever's gonna not ruin her life, basically.
Okay. Fair enough. Mr. Kirch?
Are you in fear for your safety?
No.
If she was released, would you
No.
be in fear?
Not at all.
Do you want to have contact with her?
I would love to.
Okay, and the type of contact would probably be over the phone or via email, but nothing in person. You're aware of that?
Fair enough.
Okay. How long has Ms. Gonzalez lived in Florida?
I believe she's lived for about 7 years.
Okay, and how long have you been in a relationship with her?
About 8 months.
Okay. And the address that she lives at?
5531 Southwest 55th Avenue, Dayton, Florida 33314.
And she lives with you?
Yes, she lives with
Okay, and did you want her to come back home?
Yes.
Has anything like this ever happened before?
No.
Do you know how much money Ms. Gonzalez has or what kind of job she has?
I don't know her personal finances, but yeah, she works in a company called POW.
Okay. Do you know how long she's worked there?
About a month.
Okay. I'll turn it over to the state or Your Honor if you have any questions.
All right. There'll be a bond in the amount of $500. And I'm not going to impose a no contact.
Thank you, Judge. Ms. Gonzalez, you have bond at $500. We'll work on getting that posted for you, okay?
Yes, thank you.
Don't say anything about the case.
Victor Cristobal?
Thank you.
Good luck.
Copy, Your Honor. Your Honor,
Yes, sir.
very little English.
Okay.
I don't know English, Español.
Sí, entiendo. Tomorrow?
Because yes, unless
Or
we
you
can,
want to wait? I mean, it's your call.
if we can call the
We'll
Spanish
call it. I
interpreter.
just don't know how long it's going to be.
Okay.
You want us? You're going to wait? We can call you.
Yes, Judge, I'll be here for. I have a hearing at 2:30 in Hollywood, so I have to leave in about 15 minutes. But so I'll give it.
We'll try.
Okay.
And if you have to leave, we'll just reset it for tomorrow. All right. Okay. No, you're go ahead. Go ahead.
All right, I'll tell you, have a seat.
Yeah.
All right.
Thank you. You have a case, sir?
Your Honor, I wasn't sure if it might have been on this morning and passed. I didn't see it on the afternoon docket. My client's Rondell Steele.
Yes.
It was here this morning?
Still present.
We reset him for you to be here tomorrow.
Okay.
Your name again?
David McGilligan?
Yep. Yeah, he didn't know he'd be able to get in touch with you.
Gotcha.
So we reset it till tomorrow, I believe.
Well, I mean, I don't mind. I mean, if you want to handle it now, I
You can
mean,
handle it now.
because to avoid the officer having to come in tomorrow, I'm fine. If you want to take a look at the PC,
If I could just take a look at the form?
we can get the paperwork up here.
Judge, we just have to,
We can get
the
the
court has to
paperwork.
order us to bring him to
Then
court
we-
now, right?
We can do that.
We're gonna let Mr. Is it McGilligan? McGilligan read the PC and he'll advise us how he wants to proceed. The deputy at Conti, you look like you want to say something. Oh, okay. Nicholas Vincent Lewis. Is that you at the main?
This is Nicholas Lewis, Judge.
All right, Mr. Lewis, you were charged with misdemeanor domestic violence battery. I reviewed the probable cause affidavit. Yeah, I do find probable cause. Any criminal history, Mr. Linder?
1 minute.
Oh, Patrice is here this afternoon.
Yes.
Cruelty to animals causing death, pain, and suffering. 2006, an adjudication for dealing in stolen property and providing false ownership information upon title and a grand death in all adjudications. He violated his probation on that case. 2007, also a violation of his community control. 2017, there was a trespass on occupied residence. End of record.
Okay, in contact with the victim?
There was no contact.
Okay, Mr. Miller, anything?
Judge, Mr. Lewis is advising that he's never been on community control. He is a 29-year resident of South Florida with strong family ties. He works at the Sample Spa Car Wash. No money in the bank or real estate. He is a registered voter. He does have a place to stay that's separate from the alleged victim. He is hoping that his wife, who apparently is pregnant, he has a child on the way, will bond him out. However, he was hoping the court would also consider pretrial release for him, insofar as money is very tight and they're going to have difficulty coming up with any bond amendment.
Okay. Okay, I do find probable cause. There's going to be a bond in the amount of $1,000. As a condition of that bond, there's to be no contact directly or indirectly with Jenna Lewis. That's your sister, so you know who that is. No contact means directly or indirectly, so no phone calls, emails, social media, anything of that type. Good luck to you, sir. Brandon Joseph Mateo.
Main jail.
Thank you. Good afternoon, Mr. Mateo. You're charged with one count of burglary of an unoccupied dwelling. I reviewed the probable cause affidavit. I do find probable cause and history.
1 moment, Your Honor. It's okay. He was, appears that he has a pending resisting without violence and disorderly conduct.
Say that again?
Looks like as though he has a pending resisting without violence and disorderly conduct.
Okay.
Here.
Okay, Mr. Miller?
Judge, Mr. Mateo has been living in South Florida for about 11 years. He does have family in the area. He is currently unemployed. He has no money in the bank or real estate. However, he is a registered voter. He's going to be asking his family to bond him out. And he works side jobs with his father painting.
Okay. The bond in the amount of $7,500. This isn't a, I mean, I don't
No,
see
it was. I think it was accidentally placed with the
Right, so
domestics, but it's not.
Nonetheless,
If
you'll have no contact with the listed victim, who is Brandon. No, that's you.
Henry Locke.
What is it?
Henry Locke.
Henry Locke. And stay away from the listed address.
Oh, I'm sorry.
But it's not domestic, so.
There we go.
Good luck to you, sir. Stephen Cobb, Counsel, are you ready?
Yes, Your Honor.
What's your pleasure?
Your Honor, if you could just address
We
the
don't
bond
have,
status, I don't believe there's a PC argument to be made at this point.
Okay.
If there's a bond amount that, I mean, he's a young man, he works, I'll waive his presence. For the record, Your Honor, David McGilligan, I'd waive his presence for this hearing.
I don't.
Sit down here, please. Thank you. Please.
Your Honor, he's a young man. He had been working at a Kentucky Fried Chicken. Don't know if he's still working there. He lives with his father, who I have been in contact with. I have represented Mr. Steele before. It was in a drug court matter. He successfully completed drug court. He always attended his court dates. He is, I'm not sure exactly what the facts of the case are, but I think that he's the kind of candidate for some sort of house arrest. He could successfully be relied upon to not be a danger to the community. And I know he's not a flight risk, Your Honor. He has no other ties to these. South Florida resident. Like I said, he's been, just finished up that drug court not that long ago. Always made his court dates. Never had any real issues while we're in the middle of that program.
Your Honor, the state's position as far as count 4 is, I believe, based solely on the probable cause, well, not solely, based on the probable cause affidavit before Your Honor, and I believe there was one of the ones written for one of his co-defendants in which the officer Rogers mentions that the co-defendant confessed to being in possession of a firearm, and they actually saw the firearm, the Bursa firearm, in plain view in the side panel of the passenger door. Was it this one? Okay. Your Honor, I believe there is proof evident presumption great that Mr. Steele was a principal to robbery with a firearm. Not asked that he be held no bond on that count. Obviously, counsel would retain the right to seek an Arthur hearing in division. And as far as assuming the court does find proof evident presumption great, I would just leave bond on counts 1 and 3, and solely in Your Honor's discretion.
What's his criminal history?
There's no action on drug court. There's no action on drug case, Your Honor. There was a completion of, successful completion of drug court. I'm not sure if there's any juvenile stuff to be confirmed, but I know those are 2 cases that are relatively recent, Your Honor.
Is that him, Stan? Yeah, that's him, Stan.
There was a juvenile that really isn't connected to this, Your Honor, and he did successfully complete drug court on a possession of codeine from last year, completed June 15th of this year.
Okay. All right, I'm going to set his bond similar to the bonds of his co-defendants. Count 1 is going to be a $5,000 bond. Count 2 is already predetermined. There's a $1,000 bond. Count 3 will also be a $5,000 bond. And count 4, the no bond hold will be maintained pursuant to an Arthur hearing and division appropriate.
And Your Honor, just so the record,
bond.
I was just going to say, for record purposes, the court finds proof evident or
I found it
presumption
this
great.
morning, I believe, but I'll say it again.
Okay.
Pursuant to Preston, I find proof evident or presumption great.
But Judge, is there any third party? Is there an affidavit other than law enforcement, or is an affidavit from the victim, alleged victim in this
Based
case?
on my findings on the probable cause affidavit and the probable cause affidavit of the 3 co-defendants.
And
Just for record, I just put an objection.
Part identical, but there's slight differences.
Certainly, Your Honor. I'd just like to put an objection. I don't have the case in front of me, but there's a case out of the Tampa area that says that if there's not a third-party affidavit from, not a law enforcement sworn affidavit, probable cause affidavit is insufficient to hold some proof evidence, proves no bond.
I'm not aware of that case. I'd love to see it.
Okay, I'll send a copy to chambers in the state.
And I would ask Your Honor to rely upon Brackett v. State, which is a 4th DCA case out of the year 2000, which specifically states that the state can rely upon affidavits to satisfy proof evident or presumption great.
I don't think he's saying you can't rely on an affidavit. He's saying it requires an affidavit by something other than the police officer.
Correct.
And Brackett doesn't, and it would appear Brackett, which I believe would be more persuasive since it is from this district, and I believe it's more recent because I believe I'm familiar with the case counsel's relying upon. It doesn't differentiate what type of affidavits. It just says the state can rely upon affidavits.
Understood. Well, at this level, pursuant to Preston, we're in a non-adversarial hearing. I can't hold them no bond without making that finding. I've made that finding. You're entitled to your Arthur hearing.
Yes, Your Honor.
Division.
Thank you.
I think we already know who that is. One of the co-defendants has a case somewhere. So.
Yeah, we're going to have... That's true. I just don't remember.
Right, but nonetheless, you're still entitled to a full Arthur
Perfect.
hearing in
Thank you.
Thank you. Thank you, sir. And that
Go
was
down the middle, back out. What's he saying? Same thing.
Mr. Lonsdale.
Last case, Steve Rossi just walked in. We need
Check the log, please, Al. 1 second, sir. The lawyer stepped out.
Yeah, he didn't say he was leaving.
He said at 2 o'clock he was leaving. Steve Koblik.
Need an order. Yeah.
Good afternoon, Mr. Koblik. You're charged with 1 count of aggravated battery with a deadly weapon, domestic violence. Mr. Miller there? There he is.
Yes, Mr. Miller is here, Judge.
Well, I know you're there, just when I can't see you, I get nervous. Anyway, Mr. Miller, Mr. Koblik
Yes,
is
sir.
charged with 1 count of aggravated battery with a deadly weapon, domestic violence. I reviewed the probable cause affidavit. I find probable cause. Any criminal history?
Possession of cocaine 07, possession of cocaine 96, solicitation, delivered cocaine 95, tampering evidence 90.
Judge, I didn't get a chance to talk to my client about his ties to the community. Would it be okay if I inquire at this point?
Go right ahead.
Mr. Koblik, how long have you lived in South Florida?
Since 1968.
Do you have any family that lives here in South Florida?
My sister.
Okay. Are you working?
I was working, but now if I'm here, I'm going to lose my job.
Okay. Where
I've
were
been
you
at the
working?
same place for 7 years as an accountant in an engineering firm.
Okay. Do you have any money in the bank?
No. What I'm requesting?
Can I go ahead and finish my job?
Yes.
Okay. Do you own any land or real estate?
No.
Are you registered to vote?
Yes.
Okay. Do you have a place to stay that's separate from the alleged victim while the case is pending?
Yes.
Who's going to help bond you out today?
Nobody.
Okay. Judge, we need a photo order for Mr. Koblik. I would ask the court to consider pretrial for him.
Okay, a photo order will be granted. Any contact with the victim?
Oh no, thank you again.
Sorry about that. All right, there's going to be a bond in the amount of $7,500. To be no contact with the listed victim, who is Tammy Lee Thompson. That's no contact directly or indirectly. Good luck to you, Mr. Koblik. Mr. Rossi, who do you have?
Good afternoon, Judge. How are you?
I'm well.
Good to see you. I'm here on page, I believe it's on the last page of the docket per Judge Hurley's JA. We had to reset this a couple times. Clint Albury. I don't see it,
Clint
though.
Albury?
Try North Broward with them.
It should be at North.
Clint Albury at North Broward, maybe?
That's where he was last time.
Yeah, we have him, Your Honor.
Thank you. Are you Clint Albury?
Yes, sir.
All right, there's an attorney here by the name of Steve Rossi on your behalf. Mr. Rossi, do you have an argument as to probable cause?
Well, Judge, just to bring the court up to speed on it, this is the third time we've been at a magistrate, second time I've been here. I was here on Friday. I had relayed to, who was the judge on Friday? I'm sorry.
It was Judge Skolnick.
Judge Skolnick. Yeah, Judge Skolnick was prepared to put a bond in with some conditions.
Yes, sir.
I had him evaluated by Dr. Brannon. Dr. Brannon found him to display psychotic. He made psychotic observations concerning him. There was also some medical concerns. So Judge Skolnick on Friday entered an order to the sheriff's office to do a medical and physical exam on him as soon as possible. I don't know if it's in the court file if you have it, but the prosecutor's aware of it. Because we were very concerned, quite frankly, Judge, because his pupils have been dilated for I think almost 2 weeks. and he had been previously Baker acted. We're talking about a 24-year-old that's never been in trouble, basically walks out of his house and ends up in some bushes in Coral Springs and allegedly puts a cushion on fire in a pool and then throws a TV in a pool. So that's what we have. So I guess for today, I don't know if there's any way you can check with the jail, because they won't, I can't get that information, if they did conduct that medical or psychological eval that Judge Skolnick had ordered on Friday. Would they be able to tell you that in North Broward? Because his dad was here. His dad's from out of the country, so that's why we did what we did.
I guess what we could do, let him call to talk to him. I mean, Steve, do you want to call, maybe talk to your client?
Call him on the phone and ask him.
That'd be great. Where can I call?
Mr. Osala, help me out.
All right, thank you, Judge. If you could put that on brief, we can put it on recall, or you want to just hold it for?
No, we'll just put on recall. Okay.
Thank you, Judge.
Tia Nicole Broom. Al, I guess Mr. McLaughlin was up.
Main jail. Judge, we have an argument.
Good morning, good afternoon, Ms. Bloom. You're charged in count 1, DUI, alcohol or drugs, first offense, and count 2 is driving under the influence with a blood alcohol level above a .15. I reviewed the probable cause affidavit.
Judge, I have an argument.
Okay, we make it.
Judge, according to the probable cause affidavit, the police identified Ms. Broom talking.
Try that again. I don't know what
Okay,
that was.
so according to the probable cause affidavit, the police officer identifies Ms. Broom as driving the vehicle. However, there is no evidentiary support within the four corners of the affidavit for someone to have seen her driving. No one saw her drive, no wheel witness, therefore no probable cause. I would ask that she be released on her own recognizance on this these charges.
Okay, Mr. Linder, anything?
Your Honor, my understanding is I believe Deputy Hudeke is allowed under fellow officer rule to rely upon the information, even if he's just said, this is Tia Broom, she was the driver of the vehicle, he's allowed to rely upon that information obtained by Officer Williams.
Judge, within the four corners of the affidavit, there has to be evidence, not just an allegation, but actual evidence that she was driving the vehicle. There is no one testifying that she was driving the vehicle, only that she was identified as driving the vehicle. And therefore, there is no evidence, therefore no probable cause.
Okay, well, I'm going to rely on page 2, I guess, of the probable cause affidavit, wherein Deputy Huneke swears under oath that he spoke with Police Officer Williams, who advised him that her, in this case is referring to Ms. Bloom, was involved in a crash and was the actual driver of the victim's vehicle.
Right, but Judge, how did Officer Williams identify her as the driver? It doesn't say that. The evidence that Officer Williams would have relied on is not in the affidavit. It needs to be there, otherwise there's no probable cause.
I agree that it does not say that, but I find that Deputy Huneke, and I'm sure I'm butchering his name, is entitled to rely on that.
I agree, Judge. The fellow officer rule allows the arresting officer to rely on reports by other officers, but that other officer has to have supplied the evidence that someone identified her as driving the vehicle. Okay, if Officer Williams, I can't remember his name, I apologize.
You're right, Williams.
Shows up and just says, okay, she's driving, he has to have some evidentiary basis in order for the arresting officer to rely on it. That evidentiary basis is not in this probable cause affidavit, and so, again, no probable cause.
I understand your argument. Thank you, Mr. Miller. I find that there is probable cause based on the probable cause affidavit that I read. Therefore, on count 1, there's a bond in the amount of $500, and in count 2, there's a bond of $1,000.
Judge, based on her lack of prior history, I would ask the court to consider ROR in this case.
She was arrested in Alabama in 2009 for a DUI. I do not have a disposition, though.
That charge was dropped.
Just to inform the court, we understand that the bond agent has been contacting our family.
Okay. All right, I'm going to leave the bonds as they are. Total of
Thank you, Judge.
Okay.
Lawrence, we have the Spanish interpreter. Can we go back to Conti and do Mr. Cristobal?
Yes, sir.
Thank you.
I don't think we've ever met before.
So,
Good afternoon, Mr. Cristobal.
Buenas tardes, señor
Yeah.
Cristobal.
Okay.
buenas tardes.
All right, you are charged. You have 3 warrants in case number 14,
Usted tiene 3 órdenes en el caso número 14,
9754,
9754,
MO
MO
10A.
10A.
There's a $250 bond on each count.
Cada cargo conlleva una fianza de $250.
And it looks like they're for trespassing, resisting, and
Parece que es por allanamiento ilegal de morada, resistirse al arresto
disorderly conduct.
y conducta desordenada.
There's an attorney here on your behalf.
Hay un abogado acá que está presentándose a su favor.
His name is Jara McLawrence.
Su nombre es Jared McLarence.
Mr.
Okay.
McLawrence.
Judge, I read the probable cause affidavit. It essentially amounts to him being drunk and disorderly.
Señor juez, yo ya leí la declaración jurada sobre causa probable. Básicamente se reduce a un cargo de que él estaba actuando de manera desordenada y estaba ebrio.
Did you read the probable cause affidavit when he was arrested or for the underlying offenses?
¿Lo leyó cuando lo arrestaron? O
For
lo
the
leyó-
underlying offenses,
I haven't
Judge.
seen that. I don't have that.
Lo leí para las ofensas
Have
subyacentes.
that here?
I went online. It has the notice to appear.
Lo vi en
It
línea.
basically says that he was at a location and he was told to leave by the staff. He was being loud.
Básicamente dice que él estaba en un sitio determinado, se le pidió por parte del personal del sitio que se fuera porque estaba actuando de una manera ruidosa.
And the police arrived. They told him to leave. They noticed he was drunk and he came back and then he was arrested.
La policía llegó al lugar, le pidieron que se fuera, notaron que estaba ebrio, luego se fue, pero luego regresó.
So, Judge, I don't know that if he has any prior record. I don't know what his prior record would be, but I would hope that he could possibly resolve this case with the court today. If the court would take judicial notice of his time served and give him a withhold and release him and tell him no return to the establishment.
Así que, señor juez, no sé cuáles serán los antecedentes de este individuo, pero esperaría que pudiera resolver su caso hoy, que la corte simplemente tomara nota judicial de la cantidad de tiempo que ya ha estado encarcelado y que simplemente emita un fallo sin condena y le instruya que no regrese al lugar de los hechos.
Okay.
Sir, is that what you want to do? Do you want to resolve the charges?
Señor, ¿eso es lo que quiere hacer hoy? ¿Quiere resolver estos cargos?
Sí, yo quiero hacer mi encargo. Bueno, yo no sé, pero bueno, yo estoy acá de hacer lo más posible para que me suelten.
Yes, well, I don't really know. It's not very clear to me why I'm here, but I would like to do everything possible to be released.
Okay, do you understand by resolving the charges, you'd be giving up a certain number of rights?
Bueno, usted entiende que al resolver los cargos contra usted, usted estaría renunciando a una serie de derechos.
Sí.
Yes.
Like the right to a trial?
Por ejemplo, el derecho de ir a juicio.
Sí.
The right to confront the city of Fort Lauderdale's witnesses?
El derecho a interrogar a los testigos que presente la ciudad de Fort Lauderdale.
Sí.
Yes.
And you'd be giving up the right to call your own witnesses as well.
Y también estaría cediendo el derecho de convocar a sus propios testigos.
Sí.
Is that what you want to give up those rights and resolve the case today?
¿Está dispuesto a renunciar a esos derechos con tal de resolver el caso hoy?
Sí.
Yes.
How do you plead?
¿Cómo se declara entonces?
Bueno, donde yo estaba trabajando en una compañía, supuestamente como no me quería pagar.
No culpable.
Well, since I was working at a company, apparently they didn't really want to pay me.
Decía que no me siento contra culpable y tampoco contra culpable.
and I don't feel guilty, and I don't feel not guilty.
So you are entering a plea of no contest?
Sounds like no contest.
Así que
That's the best definition of no
se
contest
declara
ever.
que no disputa los cargos.
Sí.
Yes.
So, are you entering a no contest plea? In
Así
other words,
que-
you're not admitting guilt, but you feel it's in your best interests to resolve the charges.
En otras palabras, está diciendo que no disputa los cargos. Eso significa que usted no se considera culpable, pero considera que lo que más le beneficia hacer hoy es simplemente decir que no disputa los cargos.
Sí, sí, claro.
Okay,
Yes, of course.
I will accept that no contest plea is very knowing and voluntary.
Bien, acepto ese alegato de no disputar los cargos como muy alerta e inteligente.
And it'll be a
voluntaria.
withhold of adjudication
Emito un fallo sin condena
on all 3 counts
para todos los 3 cargos
and the standard court costs.
y debe cubrir las costas judiciales usuales.
Judge, I have the name of the establishment and the address for the court.
Señor juez, tengo el nombre del establecimiento
And you're going to
comercial
stay away
y
from the
la
following
dirección.
establishment, which is
Y se va a abstener de frecuentar el siguiente lugar.
Las Carnitas,
Las Carnitas,
located at 3221
ubicado en 3221
West Davie Boulevard
West Davie Boulevard,
in Fort Lauderdale,
en la ciudad de Fort Lauderdale,
33312.
33312.
Gracias.
Thank you.
de nada.
Thank you, Judge.
Thank you, sir.
Take care.
Thank you, Mr. Mayor. Tabitha Cruz.
Bonded.
Kieri Dixon.
Main jail.
Good afternoon, Mr. Dixon. You have a violation of probation warrant in case number 15-044-394 TC20A. It's like a no-show capias.
Yes.
Yes.
It's actually, I think it's a no-show at a No, this is a VOP.
Oh, that's what it says. VOP. Sorry. Violation of probation, if I misspoke. Yeah, same case number. And you'll be held no bond until you get to see Judge Levy.
He won't. He'll have to be transferred to Central.
Okay.
Has it been transferred yet, Mr. Linder? Can you tell?
No, I believe once the clerk's office processes the paperwork from today, they'll transfer it.
Okay. Thank you.
Jorge Luis Medrano.
Judge, Mr. Medrano is present at the main jail and is interested in resolving this trespass case if the court is so inclined.
Okay, Mr. Medrano, you are charged with trespass. I reviewed the probable cause affidavit. I do find probable cause. Looks like you got your wish. You want to resolve the charges?
Yes.
You understand you're giving up a series of rights in order to do so,
Yes.
such as the right to a trial, the right to have the state of Florida prove the charges against you, the right to confront the state's witnesses, the right to call your own witnesses. Want to give up all those rights?
Yes.
How do you plead?
No contest.
All right, I'll accept that no contest plea as a knowing and voluntary waiver of your rights via withhold and court costs.
Thank you, Judge. Go. Good luck. Andre?
Mr. Alberry coming? Mr. Rossi coming back?
I hope so.
Okay. Andre Leadham,
Main jail, Judge.
you're charged, you have a misdemeanor warrant in case number 15032-916, TC30A, and a possession of cannabis 20 grams or less in count 2. I reviewed the probable cause affidavit. I do find probable cause. There is a $500 bond on count 1 and a $100 bond on count 2. Good luck to you, sir.
Good luck.
Jalen
Latham.
Coleman.
Coleman? Main jail, Judge.
Mr. Coleman, you're charged in count 1 with providing a false identification to a law enforcement officer. I reviewed the probable cause affidavit. I do find probable cause. Your bond is set in the amount of $100.
Judge, will the court consider ROR for Mr. Coleman? I believe this is his first adult offense.
Mr. Linder, you looking
I'm
at
checking
it?
that right now.
I figured you were.
You never know.
What's Mr. Coleman doing when he's not in custody?
I don't know, Mr. Coleman. Where do you go to school, sir?
AMI.
AMI? What are you studying? What are you studying at school? Yeah.
No, I'm in high school.
Oh, still in high school. When did you graduate?
What's AMI?
December.
What does AMI stand for?
High school.
Trees.
Alternative something?
Marine.
Juvenile record.
Marine. I don't know.
You don't even know the
Are
name
you
of the school
going
you
to
go
graduate?
to?
Yeah. Are you committed to graduating? You're not going to drop out and get a GED? You're going to get a real high school diploma.
I'll run track and all.
There you go. And learn the name of your school. Okay.
That should be the first question on the final exam.
It's not like you get your spelling name right on the SAT, you get a couple of.
When do you graduate? Or when are you supposed to graduate?
This year.
You're a senior?
Yeah, yes, sir. I got 3 more credits to graduate.
Okay. Are you on schedule? Are you behind? Are you ahead of schedule?
I'm ahead.
Okay. You're ahead of schedule?
Yeah, yes, sir. I got 3 more credits left to graduate, sir.
Okay. And when you graduate from high school, what are you going to do?
When you graduate high school from my school, they give you a 2-year scholarship to go to any college in Florida. So whatever college I get accepted to, that's where I'm going.
That's a pretty good offer. Can't pass that up. Did you confirm his criminal history?
He's got some. Looks like he's got some serious juvenile charges that are pending, actually.
Mr. Miller, apparently your client has some juvenile charges that I'd like to hear about, so I'm going to press the button. But Mr. Afzal's here looking out for Mr. Coleman, so you have nothing to worry about.
Probably should have just stuck with the $100 bond, Judge.
Maybe.
They get charged all the time. Not minors against minors. It happens.
Can I just withdraw the request, Judge?
I'm sorry?
Can I just withdraw the request?
Yeah, but I'm just going to take the opportunity to say that, Mr. Coleman, you're 18 as of September 29th, which means now if you get arrested, you're in adult court. And there's no more juvenile court where, I don't know what happened there or what didn't happen there, but the stakes are a little bit higher now. I really hope you graduate high school and take that 2-year college offer, get an associate's degree, and move on to bigger and better things, because the adult system is not the same as the juvenile system. I'm going to leave your bond set as it is. It's currently a $100 bond. Good luck to you, Mr. Coleman.
Thank you, Judge.
I see that. He doesn't spell it the same way now. Bob Marley. I won't make the obvious.
You bonded, Judge.
No, I didn't notice that. Maybe it is Bob Marley. Vladimir Fedotov.
Sorry, Judge, I didn't have that in my docket.
Did I skip somebody? No? Okay. Mr. Fedotov, you're charged with 1 count of burglary of an unoccupied structure, unarmed.
I'm going by what
Yes?
Brandon's telling me.
Where is it on the docket?
I have no idea. It's in my stack of papers. Fedotov? Vladimir Fedotov?
Judge, I just said PC. PC. Very questionable, Judge. I mean,
Yeah, I have it right here.
you just want a little bit more detail.
I would love a little bit more detail.
Yeah, but I just, I don't know. It's very questionable if this is enough. How do you make entry? Who saw him? What do they say? What do the witnesses say they saw? I mean, like, just a little bit more. I mean, it's a close call, Seth, in the court maybe to find no PC on this one.
Well, what I'm gonna do more than anything is I'm gonna find no PC and give you 24 hour. 24 is good, because I'm gonna have difficult. Even if I find PC, which I mean PC is a low standard. Arguably, you could find PC. I don't know how to set a bond on these facts, so I'm gonna find no PC and give 24 hours.
Okay.
Let Judge Hurley.
Thank you, Judge.
You're welcome. It's because it was you, not Mr. Miller. I think he heard me. Which one? Cedric Ward.
Mr. Ward is present at the main jail, decline PD, Judge.
Okay, Mr. Ward, you're charged with possession of cocaine. I reviewed the probable cause affidavit. I do find probable cause. Your bond is set in the amount of $1,000.
Okay.
Good luck, sir. Christopher Wayne Riker. Oh, Mr. Ross, are you ready? Or
Riker. North Broward, Judge.
Browder?
Any.
Okay. All right, we're going to do Mr. Alberry first. Is he still there?
It doesn't matter. They're both at North Broward anyway, Riker and Arbery.
Okay, we'll do Alberry. All right, you're back, Mr. Alberry. Mr. Ross, what did you find out?
Thank you, Judge. Judge, I called the Baker Act facility to see. Basically, they indicated that they cannot take him from the jail. He would have to go through a hospital facility first, for example, Imperial Point. If Imperial Point determines he needs to go to the Baker Act facility, they'll then move him over to the Baker Act facility.
Oh.
I then recontacted Dr. Brannon, who indicated, and that I could relay this to you and to the prosecutor directly, in his words, quote unquote, unquestionably, he needs to have a medical and psych eval done as soon as possible. So that being said, I've spoken with the prosecutor, Judge. If the jail, it's my understanding, at least from my client, that they have not done any psych or medical eval on him subsequent to the order entered on Friday. That being said, as a suggestion to the court, I would suggest that the BSO be ordered to transport him to Imperial Point, have him medically and psychologically cleared in the event that the jail cannot do it within 24 hours, and then we'll see what they say. I don't know what they're going to say.
The only thing I have no, if it can be done, I have no problem with it. As long, my only thing I would be requesting is that the bond be kept at no bond at this point, to ensure that whenever this is done, whenever this screening is done, he's brought back to the jail so that appropriate release conditions can be set. That's really my concern. I mean, I think we were all in agreement on Friday that he probably needs a secure facility to receive treatment. It appears that we really can't get that done at this point.
Judge, I'm sorry, just as a friend of the court, I used to be the mental health attorney. The court can send somebody to a receiving facility. The CSU, Crisis Stabilization Unit, is a receiving facility, so this is just weird them saying
It's an intake person I was speaking to, but thanks for your assistance.
But the thing is, what the court can do is send him to the Baker Act facility, order that if he's to be released, have him return back to the jail, the court can sign an order for CSU to communicate any medical or psychological information to the attorney of record, so they can update you as to what's going on with him. If he's returned back to the jail, they can tell his attorney why. I mean, those are options available to the court. But this court can send him to a Baker Act facility. That's well within the court's purview.
And as I was telling Judge Skolnick on Friday, I'm okay with any avenue of providing Mr. Albury with some mental health treatment at this point, as long as it's not going to allow him to just go out onto the street right now, because I have concerns for his safety and.
Guy who's reportedly exhibiting psychotic tendencies. I'm not releasing him out to the public.
No, I'm just saying, like, no, and whatever facility he's going to, he wouldn't have the ability to just walk out. Also.
Again, I think we're all in agreement in principle, but practically, what do I do? I don't know what facility that is that exists. That's why I made the comment of Dade County. Dade County has a specific jail and hospital, all for this kind of stuff. But we're in Broward. So
Yeah, I mean,
what am I doing with them? I mean, let's keep it simple. I don't know if Judge Skolnick found probable cause. There's clearly probable cause.
I don't know. I think he found probable cause. I can't. But frankly, it's either marked off on. Do you have the finding sheet there? If you have the finding, he either signed it and marked it off, or he didn't.
No, he just wrote mental health eval.
All right,
reset.
then formally, a judge still has to make a finding at this point.
And there is probable cause. I mean, it's not even arguing it. I mean, the facts of the probable cause affidavit are clear. There's probable cause for all 4 counts. I have to set a bond on count 1, 2, and 5. Or if you're telling me I don't have to set a bond and we can have him evaluated by the Baker Act facility. Here's what if he's let's say he doesn't meet the criteria, then they're going to send him back where we are, and we're going to be in the same boat we are, at least in terms of setting a bond. What if the Baker Act? Then what?
We just have to wait for him to bring him back.
And they're going to hold him 48, 72 hours, whatever it is.
I still think you need to set a bond, though. I don't think you. I mean, I don't know about doing a no bond hold without any further eval. I mean, I can understand if an eval came back on that, but we don't know yet.
And here's the problem. The problem is, Judge, is that I would be asking, and I mentioned this to Judge Skolnick on Friday, if we're going to set release conditions today, I'd be asking for bond and GPS monitor. They will not take him at the receipt. My understanding is they will not take him with the GPS monitor. And that's why I think the options at this point are either keep it at no bond and send him, and it's really the defense's call. Because if they want a bond, they're entitled to a bond. But it's either a bond and set release conditions today, and any mental health treatment will leave for a future date, or take action to send him to a receivership facility, but then he's going to have to be brought back and have the release conditions set when he's brought back.
Did we already go over his criminal history or lack of?
Your Honor, I don't believe that there is any criminal history. My concern is there's been previous Baker Acts, as you're familiar with. According to this, and his father was even saying his father's concerned for his own safety at this point, that he's just wandering around.
I'm sorry. November 13th, did you know an order was done for them? Friday.
Yeah, we were here. Yeah, we were all here on Friday.
But
Apparently it wasn't done.
Well, you have to give them a minute. If they're doing eval, once they do that evaluation, then North Broward will send over the thing to have them Baker Act if they feel that once he has the site eval.
But when's it going to be done?
Evaluation, you just did it on it. Today is just.
So we don't have
And that was
72
going to be
hours
my
to
next
wait.
question. How is this any different from any other defendant where we order a mental health screen?
My understanding was that this, at least from what I remember, the wording was not the same as just your usual mental health screen. Because we had another case earlier that morning where someone from Court Projects was talking about another type of evaluation they could do. I mean, you know,
All right, well,
this, like I said, once again, we really have. It seems that there are 2 options at this point: setting release conditions or sending him out for.
All right, if I set release conditions, what release conditions is the state of Florida requesting?
Your Honor, based on the allegations in this case, my concern for the safety of the community, Mr. Albury's safety, I'd be asking for, and I know it says burglary structure on count 1 and 2, but it's actually burglary of a dwelling. I'd be asking for $25,000 per count on 1 and 2, $50,000 on 5 with the GPS monitor.
Those are the only release conditions?
Well, Your Honor, at this point, I don't know if there's anything else I could ask for. I don't know if I'm in a position to ask the court to order him to get a mental health evaluation. That's
You can ask if you feel.
okay. Well, I mean, I think that would be part of what I would want pretrial to establish that he set up an evaluation, follow any recommendation from for treatment from that evaluation. Obviously, no victim contact. Obviously.
Well, if you're going to send it for pretrial, then they can go into jail and they can do the eval on him as part of the conditions of the bond release, right? Correct?
No, they send.
After he posts the bond, then the GPS monitor will be placed on him. When he goes to the pretrial office, they will direct him as to giving him suggestions as to what facility he ought to go to get the evaluation done.
Yeah, they don't really get involved until the bond's posted.
Yeah, they just make sure that he complies with the conditions, and if he doesn't, then they let me know about it. They're not going to help him do it. I mean, that's not
Yeah,
their
no.
job. So who's going to help him do it? Like I said, the big one. No, I understand that. But I mean, how do we get him from point A to point B?
Well, it would probably be, for instance, I mean, I imagine he's going to be staying with someone because they're going to have to verify. Until they verify where he's going to be staying, he's not going to have that GPS monitor put on him. And I imagine
GPS monitor on him, then they're not going to take him somewhere. You said they weren't going to take him.
Well, no. What I'm saying is for pretrial. If let's say you just set release conditions today, I'm not talking about a big ground facility or anything like that. Just release conditions. Pretrial's not going to until they verify where he's going to be residing. Then they're not even going to put the GPS monitor in because they need to know where he's going to be living.
You know the answer to that question, Mr. Rossi, where he's going to be living?
Not this time.
Like you said earlier,
His dad, but his dad was here. They have a place in Palm Beach. The dad's got a cousin over there, but the dad's from the Bahamas. So the dad's here right now, and he will actually go see his son today. He's visiting with him, I believe, but he doesn't live here.
Understood.
So there's no immediate family member here.
Well, then, unless we have a verifiable address he can stay at, then pretrial is a no-go to begin with. We're hitting a lot of dead ends here.
Yeah, I guess my main concern, Judge, I just want the kid to be checked out. That's the main thing.
He's going to get checked out in the jail as per Judge Skolnick's order.
Then what I'd ask the court to do...
I mean, I can ask them to accelerate it, but I can only ask. I can't.
Well, I understand that. I mean, I don't know much... Well, it's... the only other... Well... I guess you could set the bond and release conditions today. I think the bond is fairly high in light of the fact that he has no prior record, but I would ask that I understand that. And then the other thing would be that I'd ask that we at least have this set for like another week to check a status on this in magistrate court. The underlying the case is assigned to Judge McCarthy's division. And as I indicated to Judge Skolnick on Friday, I'm aware of her procedures, and as I anticipated, Judge Hurley's JA checked, and from my understanding, she will not set anything down unless there's a motion, etc. So by the time that's all done, again, I just, at least for the time being, I want to at least be a magistrate court so someone can at least monitor the situation.
Understood.
I mean, I guess
Can I ask another question? Because this will apply to a lot of other cases, not just this case. We order these mental health screens all the time.
Yes.
Right. Mental health screen. What happens? The jail evaluates him. They determine that maybe he possibly suffers from schizophrenia.
Well, they to me, it's more of a triage unit because the purpose of a jail is for punishment. But they have
to make sure that he's not in critical care of need of care.
But the issue, if you really feel somebody's a danger to themselves and others, the court does have the authority to Baker Act that person, or at least send them to a receiving facility for an evaluation. Have BSO transport them. The court can sign, like I said earlier, the court can sign an order that the CSUs will be disclosed to.
But in advance of setting a bond?
The court can't do that.
Based on what Mr. Rossi's telling me, based on what I read in the probable cause affidavit, there's been reference to what Dr. Brannon has determined. It sounds like a Baker Act would be the very appropriate thing for Mr. Alberry.
Right.
So
But then the thing is, with each hospital's liability policies, if you say, for example, Baker acted somebody charged with, try to Baker act somebody charged with a murder, then you got liability issues, so with safety issues, when sometimes because of their policy,
When you're
they
saying
want
order
to.
them to CSU, are you saying that as a division judge, or are you saying that as a magistrate, a first appearance judge?
First appearance judge can do that.
Okay.
Any
and-
judge can do that. I mean, if you
but
feel that
after imposing a bond,
the court can impose a bond, or
because then if I,
defer.
but let's say I follow the state's lead and I impose what's going to amount to be a $100,000 bond, he can't post that. I'm going to assume. Is he still going to get transported to CSU for Baker Act under sheriff's condition? And then if they clear him, they just bring him back here, and he can post the bond. He can post the bond. If he can, he can't.
No, but the problem is, Your Honor, is what if the bond gets posted 2 hours upon ordering it? Now you're ordering someone held where they've posted a bond, they've lawfully posted their bond, and that's part of the reason why I suggest.
Well, I can make a condition. I can make that a condition of his release. If he doesn't do it.
But here's the concern, Your Honor. Let's say, okay, hypothetically speaking, it's not just the bond; it's other release conditions. Like, let's say hypothetically, no victim contact. Well, if he hasn't been evaluated, if he hasn't received treatment, now we're relying upon an order to someone that we don't know how stable they are, and if they get released before they come back, then how secure can we feel about, I mean, because there are situations where I don't know if someone can be ordered back once their bond has been posted, if they're allowed to
Judge Secor.
someone.
I actually called mental health. You can't Baker Act a felony. It has to be a misdemeanor. I called the public defender. I let him know. That's why, because it's a security issue. So we can order it, but security overrides everything.
I mean, that's why, frankly, what it seems to me is because did Judge Brandon make a determination
Not a
that?
judge.
I mean, Judge. It's been a long. Did Dr. Brandon make a determination that he's not competent?
Yes.
It would seem to me the best way to go would be to move this as quickly as possible to just get in front of Judge Porth.
Are you comfortable stipulating
We'll have
incompetency?
I can't at this point, obviously without seeing it. I mean, I understand. I'd have to see the report. That's what I'm saying. If we could somehow, and I understand there's an issue with Judge McCarthy, but get in there as quickly as possible.
But why would it go to Judge Porter? That's what I'm.
Porth.
Porth. Judge
No,
Porth. Yeah,
Yeah.
not Porter.
It'll have to go in front of another assigned judge because my understanding from the prosecutors in Judge McCarthy's division is that she will have to disqualify herself on any case involving where Judge Brandon's involved.
Has said that before on the record, actually.
So that to me seems, and unfortunately, I wish we could do it all in the same day. But I mean, that to me it seems that's the best option at this point is getting in front of Judge Porth.
Different options.
No, getting in front of Judge Porth.
Yeah, but I can't.
I know you can't from here.
A lowly county court judge doing first appearances on a Monday.
That's why, but you're just understand, that's what we were trying to do on Friday, is get it in front of Judge McCarthy and start the ball rolling on that.
I can send you a copy
I
of
think the most important thing at this point is for Mr. Alberti to be seen at some level and determine if he's in need of immediate care. And I think the fastest way for that to happen, and the fastest legal way for that to happen, is for the order that Judge Skolnick entered on Friday to be carried out. Somebody from the sheriff's office said it will happen sooner than later. So I found probable cause. I'm going to set a bond. You said there's no criminal history.
None that I'm aware of, no.
Okay. All right, so, yes, I thank you. All right, on count one, it's going to be a $7,500 bond. Count two, it's going to be a $7,500 bond. Count 3 and 4 have previously been set at $25 apiece, and they will remain. Count 5 will be a $10,000 bond. Condition of the bond, if it is posted, is for the defendant to get a mental health evaluation and any follow-up treatment that evaluation is required. In the interim, while bond is not posted, the jail will screen him. I will reorder, if I have to, the mental health evaluation on behalf of the jail, but I don't think I need to. I think it's already been done. And the jail is certainly on notice now that this man is in need of, at a minimum, an evaluation. And Unfortunately, I think that's the best I can do.
Well, I mean, as far as the GPS monitor, because, I mean, according to this,
I'll impose them. That's fine.
Okay,
No, GPS
okay.
monitor is fair. Like, especially, yes, absolutely. All right. Anything else I can do for you, Mr. Rossi?
No, Judge. At least I appreciate you giving it your attention and your suggestions. The only other thing I would ask, can we just please set it for another status before magistrate court?
I mean, I don't have a problem.
I'm sure. When do you want to do it?
And-
Want to do it next Monday when I'm here?
Yeah,
That'd
that'd be
make
great.
the most sense.
That'd be great.
Do it next Monday.
But we don't have to go over this the third time.
Right.
Well, no, he's made the findings, but I guess you're just being reset for a status, I guess.
Put him on the second look docket for Monday.
Afternoon docket Monday?
Can we put him on the second look docket for Monday?
That's fine with me.
Yeah, second look docket on Monday afternoon.
And Your Honor, in an abundance of caution, just order Mr. Albury, should he be released for some reason before next Monday, he's not to have any contact with the victims at this residence in Coral Springs, please.
Well, if he's released before Monday, he needs to be here Monday at 1:30.
Well, I'm just saying, if sometimes crazy things happen.
No,
That's,
pardon the pun, I understand.
I know,
So,
I know.
it'll have not returned to that address. You understand that, Mr. Albury? You understand what we're talking about at all? I'm sorry?
Yeah.
Yeah?
Yeah, don't go to Coral Springs.
Yeah, good idea. That covers the whole city. Thank you, Mr. Albury.
We have to do another order.
Thank you,
now?
Mr. Rossi.
Okay. Count 3 and 4.
Supposedly the legislature's gonna take it up this year.
That would be good.
Mr. Riker? Is that you, sir?
I know.
Yes, sir.
You're charged in count 1 with burglary of an occupied dwelling, unarmed,
It's the-
possession of burglary
are you writing an
tools,
order?
grand theft,
Okay, cool.
and resisting an officer without violence. I have reviewed the probable cause affidavit.
Paperwork.
I do
Order?
find probable
Yeah,
cause.
okay.
Mr.
One moment, Judge. Your Honor, Mr. Riker is currently out on bond for dealing in stolen property and false ownership info on a pawn item. He's got 2012 robbery by sudden snatching, just under 22 months state prison as a habitual offender. 2010 possession of oxycodone, methadone, same sentence. 1999 grand theft with the VOP.
What's the case number on the dealing with stolen property?
15, I need an order. 11421 CF10A.
And that's 15011421 CF10A?
Yes, sir.
Is that on release for dealing in stolen property?
Dealing in stolen property, false ownership info, pawn item.
Is Mr. Riker correct?
Yes.
I understand that the warrant was sent to Judge Barrigan. I also understand it has not yet been sent.
Oh, so are you doing an order or am I doing the order?
A warrant was done and sent to Judge Barrigan, so I don't present one to the magistrate. So if you want-
I'll write an order for the court.
Mr. Hofstad, I know you were on the phone. Did you want to address Mr. Riker? Go ahead.
Sir, what city do you reside in prior to your incarceration?
Pompano.
Do you live in a house or apartment?
Apartment.
Do you pay rent there?
Yes, I do.
How much do you pay a month?
Like 600.
Were you working?
Yes.
What do you do?
Excuse me?
What did you
What
do?
do you do?
What's your job?
Oh, I work at T&M Windows.
Okay, how long you been there?
For about 3 years.
Do you have any money in the bank?
No, I don't.
Do you own any property?
No,
How long you been in South Florida?
my whole life.
Who's gonna bond you out?
I don't know, sir.
Do you have family or friends here?
I have family.
And where do they live?
My sister lives in Coral Springs. My mom lives on the West Coast.
Okay. How much bond can you afford?
Right now, I don't think anything right now.
Who lives in the apartment with you?
Actually, I go to First Step. It's First Step Silver House.
Oh, first
That's
steps.
where I live.
Okay.
Yeah.
All right. Judge, I would ask. I mean, if he's at the first step over house, maybe release him back there on pretrial. Is this a robbery?
Just remember, you got to do.
Prior robbery, this is burglary.
You got to do all the.
All right, I've reviewed the probable
charges
cause
and
affidavit, take into consideration the facts in the probable cause affidavit, the fact that the defendant is out on pretrial release, dealing with stolen property in case number 15011 421 CF10A. Court's going to impose a $15,000 bond on count 1. There's a $1,000 bond on count 2, $1,000 bond on count 3, and a $100 bond on count 4. In addition, the court's going to revoke the pretrial release status of the defendant in case number 15011 421 CF10A. Pose a no bond hold.
Hey, did you?
Maybe Mr. Epsal should ask him that. Yeah, he's going to be in. We used to. Oh, absolutely. You're going to give me a word, Patrice, or do I do a blank one?
I got it.
You're all done, sir. Kimberly Situte.
Main jail.
I mean,
Long time no see, Mr. Miller.
Judge, I missed you, but I did have a nice nap while I was waiting.
Count 1, Mr. Situte, you're charged with possession of marijuana, 20 grams or less. And count 2, you have a warrant in case number 1401828, CF10A. Looks like that's a no-show.
Judge Singal.
Yes, and there's a $100 bond on count 1. You'll be held no bond on count 2, and you'll see Judge Singal on the 18th at 8:30 in the morning.
5-0.
Thank you, Judge.
1-5.
Off you go. Ingram. Sebring.
David Ingram.
Medical loan.
He's on loan, Your Honor.
Thank you. We'll reset tomorrow, 1:30.
Dunning's on loan also.
Okay. Do the same there. Patrick Sebring?
Main jail.
Mr. Sebring, you're charged count 1, petty theft in the second degree, third or subsequent offense. Count 2, resisting a merchant. Reviewed the probable cause affidavit. We do find probable cause. There's a $750 bond on count 1, and there's no charge for count 2.
Thank you, Judge.
Luke Matthew Carmichael.
North Broward.
Judge Secor, he is at North Broward Medical Reset. And I have just one on the second look docket. Robertson, Elliott, if you like to see him.
Sure.
Come on, Mr. Robinson.
Yeah, Your Honor, this charge has been filed.
Here it is. What's your name, sir?
Elliot Robertson.
Elliot Roberson. Okay.
It's a 30-day. It's been filed.
Mr. Roberson, the charges against you for aggravated battery on a person 65 or older, trespass, and misdemeanor battery have been filed.
Your Honor,
So you're
sorry.
Go ahead.
The charges filed are aggravated battery, armed trespassing, and 3 counts of battery. He is scheduled for arraignment before Judge McCarthy on November 23rd, 8:30 in the morning.
All right, so the charges have been filed against you. Whatever bonds are in place shall remain, and you have an arraignment on November 23rd, which I believe is a week from today.
Yes, sir.
Good luck to you, sir.
I thought, Your Honor,
Yeah.
I thought I had to change the charge to trespassing.
Yeah, but you're still charged with aggravated battery. I didn't do it.
Aggravated battery.
Don't get upset at me.
So I have no bond still?
What was your bond on the aggravate? What was his bond? Anybody know? Doesn't tell me here.
One moment.
There's going to be some additional bonds though, because it looks like there was some change of charges. So.
Yeah.
It looks like it was originally a burglary with a battery. Now that there's a change of charge, they'll process the paperwork and bring him back to have a bond set.
They're going to bring you back to have a bond set. Probably on.
It'll probably be the next couple days.
Yeah, sometime the next couple of days. And lucky you won't have to see me. It'll be somebody else.
All right.
Good day to you, sir.
I say good day.
Because we don't have the facts. We're here for 30 days.
What do you got, Mr. Miller?
I'm here, so.
Judge, this is Donald Skinner. He is here for a 30-day motion.
Donald Skinner,
Yes.
possession of PVP, resisting a...
Your Honor, we've not yet filed charge. He's entitled to release.
Mr. Skinner, the state of Florida informs me they have not filed the charges against you within the requisite 30-day time frame. Therefore, you are entitled to an ROR. Good luck to you, sir, and stay away from the flocka.
All right, thank you, Your Honor.
This hasn't there. Allegedly.
Who's that?
Judge, this is Aston Humes. He is here on a second look, petty theft, and resisting without. He is interested in resolving if the court is so inclined.
What was his name again?
Humes. So the misdemeanor.
Aston.
This docket over here. My docket shows 2 counts of resisting without. Is that not what you said?
I said resisting without and petty theft. I did not see 2 counts.
Okay. I don't have any paperwork up here, but I usually when I see what I'm seeing with that color and waist chains, it means there's something else going on.
Well, no, Your
He's
Honor.
informing me that there is nothing pending, nothing else pending.
You don't usually see that on a petty theft and a resisting without.
It
No,
stems from the charges he was arrested for 2 weeks prior. He was picked up on a domestic violence battery that was no infoed, but he also had juvenile court-ordered holds and some felony level violence.
Okay. Well, I'm amenable to looking at a report to see if I can resolve it, but I don't have it. You have anything?
I can get something.
Thanks, Judge.
All right, Nicole Egan.
Okay.
I have to recall you, Mr. Miller. Give me a minute. Nicole Egan.
All right, Your Honor.
All right.
All right, what's going on with her?
30-day or a second look?
No, it's a second look, Your Honor. When she was brought in, when she was first arrested. Wait a minute. Yeah, I don't. Do you guys know? Did she posted her bond on the felony charges that are holding her? So I guess she's got a second look on misdemeanor and felonies, Your Honor. There's one case of uttering a forged instrument and grand theft that she's got a $2,000 total bond, and this misdemeanor case of theft and caused the child to become delinquent at $350 total on that.
Okay.
The child's not delinquent.
Okay.
I can tell you. One moment. Patrice, do you happen to have any notes about priors or anything? Or? Okay, one moment, Judge. Okay, makes sense. Basically, what happened, Your Honor, was on the felony counts, it was a not in custody affidavit.
Okay.
So when she got arrested on the misdemeanor counts, the new petty theft and child neglect, they found out that there was still this. They found out then that there was a felony warrant for the not in custody case. So I guess the reason why she wasn't put on pretrial or anything the first time is she's out with the warrant on the grand theft, and now while that's going on, she's committing a petty theft.
But the grand theft was a not custody case, you said?
Yes. Yeah, she didn't violate any release conditions, but...
Okay. And the bonds are in what?
The 1,000 each on the
What felonies?
on the felonies, and total of 350 on the misdemeanors.
Judge, at this juncture, she was unable to afford bond, so I don't think she has the ability to bond out at this juncture, being in custody as long as she has. May I just make a brief inquiry if the court...
Right.
Miss Agan, do you have a place to live?
I do.
What city?
Miami.
Is it a house or apartment?
A house.
Who lives there with you?
My family.
Who's your child with right now?
With my parents.
Okay. Have you... how long have you been living in South Florida?
My whole life.
Do you have any money in the bank or any property?
I do not.
I would ask for pre-trial, Judge. She does have a place to stay. Her child is currently with her parents.
Okay.
No money in the bank, no property.
No, I understand. I was going to wait for Patrice and ask if pre-trial, you know, if pre-trial has confirmed her residence.
Yes, her address has been verified.
Okay. I'll put her on pre-trial release for both cases. Ma'am, pre-trial, you're going to be put on pre-trial release. You're going to have to report in person as soon as you're released, then you're going to have to report by phone twice a week. Okay?
Thank you, Your Honor. Thank you.
You're welcome. All right, Mr. Miller, I got something on Hume, so I'm going to read it now.
Thank you, Judge.
Okay, and Mr. Linder, other than what I just read, there's nothing holding him?
No.
Nothing pending?
Nope. Well, I mean, there might be juvenile charges pending. I don't know, but it's not they're not holding him.
Right, understood. All right, remind me what it is again you would like, Mr. Miller, what you're speaking on behalf of Mr. Humes.
Mr. Humes would like to resolve this case if he can.
Mr. Humes, you're 18?
Yes, sir.
Going to school?
Hey, were you?
Yes, sir.
Where you go to school?
At North University.
Whatever.
At university? You go to university school?
I'll just mess.
Nah, it's an alternative school.
And what's the name of it?
North University.
North University, okay. When are you going to graduate?
I'm trying my best to get my GED if it's possible.
Well, I think it's necessary.
It doesn't.
Yes, sir.
Understand?
I don't get anything out of it.
Yes, sir.
And you can't stop with the GED.
That's right, sir.
wanna-
That's just the starting. Because I'm 18 already.
Right, you're 18, which means any new offenses qualify for adult court. You're not going to be in juvenile
Yes, sir.
court anymore.
Yes, sir.
It's a you're in the big leagues now. Okay? Pitches come a lot faster
Yes,
and
sir.
a lot harder to hit. Understand?
Yes, sir.
You want to end this nonsense, right?
Huh?
You want to end this nonsense, right?
Yes, sir.
Waist chains, jail,
Yeah,
hanging out
right,
with
sir.
Mr. Miller. You're going to cut all that out.
Yes, sir.
You're going to do that by way of getting an education.
Yes, sir.
It's the only way.
Yes, sir.
No one's going to hand it to you. You got to work for it.
Yes, sir.
Okay?
Yes, sir.
But you got to. I appreciate the yes, sir. And it's very respectful
Yes, Your
of you.
Honor.
It's very respectful of you, but
Thank you, sir.
it takes more than just yesing people. You got to pick up the ball
That's
and run
right,
with
sir.
it. All right, you got to do it yourself.
That's right, sir.
All right, now Mr. Miller
Yes,
tells
sir.
me you want to resolve these charges.
Yes, sir.
Would you like to do that?
Yes, sir.
You understand by doing that you'd have to give up a bunch of rights. Do you want to give up those rights?
Yes, sir.
You know what some of those rights are as an 18-year-old working towards his GED?
Yes, sir.
Tell me some of them.
Adjudicatory hearing, right to remain silent, right to have an appeal. That's just a couple I could go with.
That's all right. It's a good start. You have a right to a trial. You have a right to require the state of Florida to prove the charges against you. You have a right to an attorney. You have a right to call your own witnesses. You have a right to confront the state's witnesses. But you'd be giving all those up if you want to resolve the charges today. You don't have to. It's your
Yes,
choice.
sir. That's right, sir.
You want to give those rights up?
Yes, sir.
Okay.
Are you?
I will. How do you plead, sir?
No contest.
All right, I will accept that no contest plea as a knowing and voluntary waiver of your rights. I'm going to impose a
Thank you,
withholding
sir.
court costs on both cases. And you need to do yourself a favor. Forget about everybody else. Just do yourself a favor and get that education, okay?
Yes, sir. Thank you for that advice, sir.
All right, good luck to you, sir.
Good luck.
For me.
That's it. You will be soon.
Okay, sir.
Good luck. Judge, that clears us at the main. May I be excused?
Yep. See you next week, Mr. Miller.
Thank you. Actually, I'll be on vacation next week. I'll see you the week after.
You're each one, right? All right, who we got? We got Jessica Pinero.
Yes, Your Honor.
She can be ROR on both of our cases.
Good afternoon, Ms. Pinero. You're charged with possession of heroin and suspended of driver's license. The state of Florida informs me they have not filed the appropriate charges against you within the appropriate time, and you're entitled to an ROR. Doesn't mean the charges go away. That just means you get to get out. Understand?
Yes, sir.
All right, good luck to you, ma'am.
Is that for both of my charges?
Possession of heroin and driving on a suspended license. Yes, ma'am.
She's got 2 cases.
Oh, you have
Okay,
another
but
case?
I was arrested.
Hold on, it's not in order on the docket. Is that the same on the other heroin and drug paraphernalia?
Yes.
Yes, it's on both cases. Okay?
Okay, and the bonds are still on the other charges, correct?
No,
I have
you're
two
Well, she
cases
might
that
be
were
held a
filed.
lot more than that. So.
If you have other cases, yes, those bonds are the same.
Okay.
We're only talking about the 2 heroin cases.
Okay.
So if you get out, you got to stay away from all that stuff. It's just going to kill you.
Yes, sir.
Okay.
Thank you.
Good luck to you, ma'am.
Thank you.
Stephanie Joseph.
She can be ROR.
Okay. Ms. Joseph, you are charged with possession of PVP. The state of Florida informs me they have not filed charges within the appropriate time frame. So you are entitled to a ROR, so you will be ROR'd. Charges don't go away, it just means you get to get out, okay?
Okay.
Stay away from the PVP.
Thank you, Your Honor.
It's FLACA. It's bad.
Thank you.
Atmi Rizvani. Turn
Your
on the
mic
mic.
is off.
Conti, your mic's off. Turn. There you go. What
Oh, he's not here. He went downtown to court. He has PM court downtown.
Okay, thank you.
Rizvani, we have not yet filed. He's entitled to ROR.
Well, he's entitled to an ROR nonetheless, so we'll ROR him on that count. John Calaveratino. Wow, Calaveratinos.
Yes, sir.
How do you say your last name?
Calavertinos?
That's exactly what I said.
Yes.
Mr. Linder?
Your Honor, it's been filed as a misdemeanor theft. Since he's been in over 30 days, I have no objection to an ROR. He just needs to know that the case has been filed. He's either going to get court notice. Even if he doesn't get court notice, that case is out there. So he's.
You hear that?
Yes.
So they're agreeing to the ROR, but the case was filed. So that means
Okay.
look for something in the mail in terms of a court date.
Yes, sir.
All right? Because the case is pending and you're going to have to come back for it. If you don't get
Okay.
something in the mail, be proactive. Look on the computer.
You got it.
All right. So you'll be ROR.
Thank you.
Donald Skinner, we already did him, didn't we?
No.
Donald Skinner? Yeah, we already did that one.
Did we? All right.
Oh, yeah, it's written right here, R1. That was Dale's. I knew it was
Okay.
LaShondra Seymour.
Has not been filed. She's entitled to release.
Good afternoon, Ms. Seymour. You've got several charges. Most importantly, possession of flakka and possession of marijuana. The charges have not been filed against you in the requisite time frame, so you're entitled to an ROR. That means you get to go home. I hope you keep that smile and come back and face the charges appropriately, but stay away from that stuff. It's going to kill you. You got such a beautiful smile. It's going to ruin it.
Thank you.
Okay?
Thank you.
Stay away.
Yes, sir.
Seriously, stay away from that stuff. Horrible.
Yes, sir.
Killing people. Ryan Grenga.
It's not been filed. He's entitled to release.
Oh, yeah.
Mr. Grenga, you've got possession of hydromorphone, possession of a controlled substance, and some misdemeanors. The charges have not been filed against you within the requisite time frame. You're entitled to an ROR. Therefore, you shall be ROR'd. Understand the charges don't go away. It just means you get to get out.
Yes.
You will have to come back to court more than likely if they do get filed. Understood?
Yes.
All right, good luck to you, sir.
Thank you.
Charles Eason.
This was actually upfiled from misdemeanor to a felony.
Based on priors.
Yes, and bond. It looks like bond was already set over the weekend at $2,500.
Okay? So it looks like you've been charged with felony battery based on prior convictions, and your bond has been set at $2,500.
Yes, sir.
Okay. Good luck to you, sir.
Yes, sir.
Anybody else? That's all I have. Nobody at Conti, nobody at Rhine. Miller shut off the lights over there, and they shut off the lights at North Broward. All right, I think that ends the docket, the PM docket at 3:07 p.m.